So we're going to give everyone another minute or so to join us, and we'll get started.
I have not heard
Okay.
so much silence in a long time.
So let's get started. Welcome and thank you all for joining us today for our program on protecting students on university campuses from increasing levels of anti-Semitism. Today's event is hosted by the Remedies Law Society, Canada's hub for Jewish legal professionals and law students. My name is Elite Aronson Mannheim, and I am the manager of the Legal Affairs Department at NABRITH Canada. If you have not yet joined the Remedies Law Society, we encourage you to do so. The organization opens doors to a range of exclusive opportunities tailored for legal professionals at every stage of their careers, from focused continuing professional development programming to unique advocacy and networking opportunities with prominent lawyers and activists. Our society provides a platform for growth, connection, and meaningful contribution. Members also have a chance to engage with major human rights cases through NABRIT League for Human Rights, intervening before the courts in highly publicized cases. I encourage all of you to actively participate in the Remedies Law Society and take advantage of these exclusive opportunities. And now, for today's program, we are privileged to have two highly experienced lawyers as our panelists. Mr. Michael N. Bergman is the founder and principal of Bergman and Associate. He is a veteran legal strategist, a relentless negotiator, and a seasoned litigator. Going on 40 years of law practice, he has pleaded before the Trial and Appellate Court of Quebec, Ontario, the Trial and Appellate Federal Court, the Supreme Court of Canada, the United States District Court, and diverse administrative bodies. Mr. Bergman has represented clients before official committees of the Parliament of Canada and the National Assembly of Quebec. He has steered and coordinated international litigation between several countries. I would also like to introduce to you Mr. Michael Tepper. Mr. Tepper is a U.S. business advisor and a member of the Ontario and New York bars and works as a U.S. tax accountant. In his spare time, he's active in confronting anti-Semitism in the education sector and in holding school boards accountable through the Freedom of Information laws. He is also a board member of the Canadian Anti-Semitism Education Foundation. I'm honored to welcome Michael Bergman and Michael Tepper. Now, let us get started with the conversation. Firstly, Mr. Tepper, can you please give us a brief overview of the current landscape of anti-Semitism on university campuses in Canada?
Thank you. Yes, the situation has always been somewhat hostile to Jewish students, particularly Jewish students who are supporters of Israel and the activities of the Israeli government. But it's gotten a lot worse. Campuses across the country certainly did not start on or about October 7th. About 2 years ago, just as a case in point, and the Scarborough campus student union, the campus executive passed a resolution condoning, well, not just condoning, but affirming the student union's support for the movement of the boycott, divestment, and sanctions movement, and also banning the participation of any pro-Israeli points of view. Specifically, the resolution, just as a case in point, said that that the student union would refrain from engaging with organizations, services, or participating in events that further normalize Israeli apartheid in ways including but not limited to inviting speakers who are representing the Israel Defense Forces or support the military occupation of Palestine, the displacement, incarceration, or killings of Palestinian people. So this was clearly an example of viewpoint discrimination. And you'll notice the way that they frame the resolution is that by vilifying people who support either the existence of Israel or any policy or activity of the Israeli government as supporting the military occupation of Palestine or incarcerations or killings of Palestinian people, making it sound like these people are unmitigatedly evil. This kind of framing exercise definitely marginalizes and ostracizes a large number of Jewish students and non-Jewish students who support the state of Israel. And it elicited quite a hostile reaction from the University of Toronto administration. But the administration's reaction was words alone. And I raised this issue as a case in point because this is pretty typical of what I've seen at the universities throughout Canada, which is, and the University of Toronto being Canada's largest university and most prominent, does take the lead, in that the student unions come up with these very radical proclamations, and sometimes they even take action. And the university administration comes back with sometimes tepid words, sometimes strong words, but they're words alone. But those words do not necessarily countermand what the student society has done. This has also come to a head at York University recently, where the York University Student Union went farther and actually declared that they were sympathetic and supported the so-called resistance against the government of Israel, not only in Israel but worldwide. And the York University administration has started proceedings to decertify recognition of some of those student societies. So you will see as an overview that the student organizations are getting increasingly radical. The university administrations are responding at least with words, but the process of taking action is long and slow. So I'll just leave that as the overall introduction.
And what are some of the methods we as lawyers can use to address this rising anti-Semitism at universities?
Well, I propose really a three-pronged approach. There are three components to this overall model. One is litigation, whether it be a class action or an individual lawsuit. There are human rights complaints, although the complaints to the Human Rights Tribunal have historically been unsuccessful in the university context because the Human Rights Tribunal looks at universities as being autonomous institutions and are very reluctant to intervene in university affairs. There have been several rulings in that area. And the third type of litigation would be perhaps disobedience to some of the policies taken by the student unions as a test case, and then let that disobedience work its way through the courts. Again, long, slow, and expensive. The second prong is student politics itself, mobilizing the election, of student leaders who will not tolerate some of these resolutions, monitoring student council politics, and mobilizing the student body to take action. Those are not quite as long and slow, but they are also somewhat expensive. There has to be time and money spent, and it's a lot of work because the institutions are diffuse, and it requires a lot of on the ground action who are really people who are really there. The third aspect is education, promoting the notion that academic freedom includes the freedom to support Israel, because the climate for students and professors who do not automatically denounce everything that happens in Israel is increasingly hostile. It's about publications and postering, getting the word out, and by offering events such as an Israel Day or an Israel Week to counteract the interminable Israel Apartheid Week demonstrations that take place on all of the campuses.
Thank
So
you.
those are essentially the three prongs. These are parallel operations. It's not supposed to be one at the expense of the other.
If I may add a comment with the moderator's permission.
Absolutely, always.
Everything that Michael Tepper said is important and must be taken into account. I want to add this. The situation of Jewish students and the cause of Israel on university campuses in this country is dire. Our adversaries, our enemies, have succeeded over many years in creating an atmosphere at universities which is a breeding ground for anti-Israel, anti-Semitic, pro-Palestinian, and other causes, which inform the intelligentsia of a new generation. This problem is serious and getting worse. And we are losing the battle right now. I also want to flag this. Very few people, even fewer lawyers, understand the legal relationship between the university, the student government, and the students. Quite often, it's not an obvious relationship. It's a complex legal relationship. And it is important to remember when we talk about university and students, the students are not children. They are adults who are being taught and influenced to a certain point of view. I'll speak a little later about what I think the appropriate legal recourses are, but I've interrupted. I'm sorry.
What are the other methods that can be used effectively to combat anti-Semitism on campuses, and what challenges might arise? This is a question for Michael Bergman.
Well,
Thank you.
Sorry.
Pardon me. Again, you need to understand the legal relationship to know what other methods there are. Usually the student government is a separate corporate entity, usually a not-for-profit. In some provinces, there are statutes that make the student government a prototype of labor union. So understanding that, we then look at the policies, bylaws, directives of the student government, usually crafted in a way to say that they believe in equality, in non-discrimination, all of this nice stuff. So first step in combating this problem is to understand the progressive left, the pro-Palestinians, the anarchists, and their fellow travelers have largely succeeded in infiltrating the student government and getting themselves elected positions of authority. To get them removed or a new cohort elected is an enormous undertaking because Jewish students would need to organize. They need to attract their fellow students who are not Jewish. Usually they don't have the time, the skill, or the money to do this. Usually they need help from the outside. In many cases, the pro-Palestinian supporters, particularly a group called the SPHR, Solidarity for Palestinian Human Rights, which exists on most North American university campuses, usually they are supported and assisted from the outside, possibly, some rumor, possibly from the Middle East. Usually the SPHR and their fellow groups do not want to disclose who are their members or who is their executive. So in organizing a campaign against these people and their election to governance in student government, you need a very dedicated group because the usual campaigning doesn't really work. Most students don't vote in student elections. It needs really an active recruitment of students to participate. Using legal tools, there's an issue of whether or not these student governments have violated their duty of fair representation of Jewish students. Their duty to treat everybody equally. There may exist in law oppression remedies to deal with this. There may be the possibility of injunctions to compel the abstaining from BDS and other movements. But all of this takes time and it takes coordination. And do not expect, in my experience at this for over 22 years now, stemming back to the Netanyahu riot at Concordia University in the year 2002, don't expect this to happen overnight.
Thank you. And this is a question for both of you. How can lawyers collaborate with student groups to effectively address anti-Semitism? Mr. Tepper?
Well, I think the leadership has to ultimately come from the student groups, because sitting in my office, there's a limited amount that I can do to influence events on campus. In order to influence events on campus, you have to be on campus. So the leadership really has to come from the student groups, and as external lawyers, that's not what I do. That's really for the Hillels and the Jewish student unions and the other student leadership structures at the universities themselves to identify issues, monitor the situation, and then they can come to us for advice and assistance. And it can be activities such as seeking injunctions when the student union is violating its own constitution or its own bylaws. It's about formulating the right resolutions in the language such that it will not be rejected, and offering advice in organized. This is not only strictly legal advice, but also political consultancy advice and organizing campaigns to get the vote out. Very often, I think it was a commentator once said, the future belongs to those who show up for it. The decisions that get made at these student union meetings get made by those who show up for them. So it's very much a get the vote out campaign. And quite frankly, they're better at it than we are. They are more organized. They know who to contact within their own student unions. And sometimes we're struggling at the last minute. But what's also important is timing. because we need to have people who are monitoring what's going on in the student union so that as soon as resolutions are proposed, we find out about them, because very often we find out about anti-Israel or BDS resolutions at the last minute, 24 or 48 hours, if we're lucky, 48 hours before they're actually tabled. And when the meeting is called, and then we're struggling to get the vote out on an emergency basis. So we have to be prepared on two levels. One is to have our database, our Rolodex of all the students that we can identify, so that they are at the ready in case an emergency shows up, and also to make sure that we are monitoring what the student union does so that there isn't an emergency. And most of these student unions have in their procedures some form of advance notice, and they should be held to it. So if they don't give out the requisite 72-hour notice or whatever the notice period is for a resolution to come forward, then there need to be people who will shut it down and say, no, the notice period wasn't given. This resolution is out of order. And we need to have student leaders who are well versed in the parliamentary procedures of these organizations to shut those kinds of resolutions down.
So if
Mr.
I
Bergman?
could add, in my view, perhaps a little different with respect. I do not believe that students alone can deal with the issue for a variety of reasons, which I've already alluded to. I believe that if the community wants to take concerted action, it will need coordination of Jewish students from outside the university. It needs a plan. It needs developing a Canada-wide, university-specific Jewish students' society, to which in each province or major center there is a lawyer or lawyers connected to sit down and strategize the specific situation.
I fully agree with that.
Campus.
Students cannot do this alone. You cannot expect second and third year undergraduates to have all the savvy of parliamentary procedure, but they are the people who are on campus who can actually collect the information. The Central National Organization is probably ill-suited to doing that. But once they have that, they need the advice and the counsel and the resources of the national organization to support them as they go forward and take action.
I concur with that. But I want to emphasize, at least in my experience, the student societies, the student vehicles. Many of the student clubs have already been infiltrated by those who oppose us deliberately. So it makes the task of information gathering more difficult. This is why I think that there needs to be a broader national-based, campus-specific Jewish student organization. Secondly, we need to, at every moment where there is hate literature, anti-Zionist, anti-Semitic, to me they're both the same thing, propaganda, literature, speeches, we need to take action. The students need to be empowered to go to court or take the appropriate action. We cannot count on the university administration to necessarily do the right thing, because in some instances they can't, because of legal structures. You have to remember the professorial class in university, many of which, particularly in arts and humanities, are generally pro-Palestinian, and in their lectures tend to explain and propagate this idea. And we need to also inform Jewish students about what actually is going on. I'll give you an example. I know a medical doctor. His daughter is in university. She's taking a course on the Holocaust. The lecturer is a teaching assistant doing his PhD. He gives the class 5 minutes before it's time to complete. He says, "Excuse me, let me share with you some personal views on the situation now since October 7th in the Middle East." He says to the class, "Israel is an apartheid state." Imagine that for somebody lecturing on the Holocaust. But that's not the real problem. The Jewish student, the daughter of this person, she wants to speak out. She wants to say something, but she has a big problem. She has no idea what the word apartheid means. Think about that. Because the terminologies, the lexicon has been seized on by our opponents and redefined, number one. And number two, most people under a certain age don't know the history and don't know what the words mean. So it's very easy to be in a stupor because you have no idea even what to say. And most non-Jewish students who have less knowledge about Israel, Middle East, and Jewish matters, they have no clue at all. If they do care, they don't know what to say. Education is important, but the ability to be a wordsmith and to use the words effectively against our opponents, just like they have been effectively using the words and phrases against us, that's something that needs to be worked on, even in court. When we go to court over these kinds of cases, most judges have no idea what the real story is, what's going on. They know there's a freedom of speech issue. They know there's something to do with hate speech, which is problematic because in law, how you define hate speech is a whole debate by itself. But we don't even have the language tools to assert our cause effectively. There's a lot of work to do. And the day is late. Even if this kind of discussion that we're having right now, very serious, extraordinarily urgent, and important, the effects of it won't be felt, if there are effects, and I hope there are, until the fall of 2024. We're losing time. Meantime, of course, our adversaries are benefiting from the propaganda by which the events in the Middle East are being distorted. You know, the old cliche, a lie gets around the world before the truth even gets out of bed. That's very applicable here. But there's another problem. Nobody seems to know in the broader society or in university setting what exactly is the truth. And we have not been able to get that truth out there yet, even in a court of law. And yes, courts are reluctant to interfere internally with universities. In my view, though, this is not an internal university matter. This is not like plagiarism, disciplinary against some sort of harassment or improper conduct or whatever. This is about the very nature of the fiduciary duty of the university to the student and the duty of the student government of fair representation of its constituency, and whether or not the students themselves, Jewish or non-Jewish, want to be engaged.
So I wanted to just draw a little bit of a distinction between what a lot of us are reading about on-campus events in the United States, particularly at some of the Ivy League universities, Harvard and Yale, even Princeton, and what happens in Canada, because we don't really have private universities in Canada. Universities in Canada are more like the state universities in the United States. And because they are state funded universities, every single university has on its governing council representatives from the provincial government. For example, the University of Toronto has provincial government appointed governors. And so those governors are the public's voice in the governance of the university as a whole. And I think the provincial government needs to cause those members of council to speak up and advocate for policies that respect the rights of Jewish students and promote an atmosphere of political neutrality, at least on campus, and a true version of academic freedom. And while we're on that subject, I'd like to just talk a little bit about academic freedom. There have been several cases on this, starting with McMurrock and University of Guelph, which was actually a mandatory retirement case, and then which hit the Supreme Court of Canada. And then there was a case in Manitoba that actually defined the concept of academic freedom quite extensively. It was University of Manitoba Faculty Association and University of Manitoba from 1991. And both of those cases set out that academic freedom is a matter of contractual relations between the university and its faculty. It's not this freestanding value that is honored by the courts in the sense that universities professors get greater freedom of speech than everybody else. We all have the same rights under the Charter of Rights and Freedoms, avoid libel, slander, hate speech, etc. The concept of academic freedom is merely that a university professor cannot be punished for the content of their academic viewpoint expressed in the context of carrying out their academic function. It doesn't mean that a professor of sociology has complete academic freedom to talk about something completely outside of their scope of practice, such as whether vaccinations are medically effective. It doesn't mean that a professor of mathematics has complete academic freedom to grade a student positively or negatively because that student participated in a pro-Israel demonstration. So the concept of academic freedom needs to be looked at from a purposive approach, which is to guard the pursuit of truth and the academic excellence of the university itself, not to create some kind of free-flowing license for any particular professor to say anything they want or to treat students or colleagues unfairly. And when those things do happen, there are internal university processes which need to be pursued rigorously. And again, that's where a national student and academic support organization offered by one or more of the major Jewish organizations could be of assistance.
Thank you both. And just to clarify or to our audience, how can we legal professionals work within the university governance to address anti-Semitism? And what legal measures can be taken when students are faced with anti-Semitic resolution, boycott, or administrative challenges?
Well, that's a very good question. It kind of leads to it's kind of a double-barreled question. One is what happens when students are faced with these policies, such as a student union that declares a BDS policy for the union. One option is to engage in litigation against that policy, and also to pursue remedies within the structure of the university. Such as a request for the university to withdraw funding from that student union. I know that B'nai B'rith has been engaged with the graduate student union at the University of Toronto for many years and actually did score a success in that area. And it was the result of several years' work by activist students and BBC. That could be done at other universities. It's a long, slow process. As Michael Berman said, time is short. We don't really have much time for those kinds of processes. And the bigger problem is that students are in and out of the institution in 4 years. And for the first 2 or 3 years, students might be intimidated from coming forward because they still have to deal with the place. from standing from outside the university, we can intervene, we can write letters, we can make our own complaints, but we can then walk away and we don't have to face the day-to-day consequences of life on campus, whereas first, second, and third year students do. Then when students hit their final year, they might be a little bit braver and more emboldened, and they'd say, yes, I'm willing to go for it, I'll be the plaintiff. But then after that, they might still legally be the plaintiff because historically they were the subject of the treatment and would have standing. But from a practical matter, they've left the university, they've got jobs, they've moved on with their lives. They might have even left Canada, who knows? And they may no longer want to participate anymore because we're all lawyers. We know that every successful attempt at litigation needs two things. One is you need to have a good legal case, but you also have to have a strong plaintiff. And a strong plaintiff, someone who's committed to the litigation and also has a sympathetic case. And so then you might have the plaintiff with the sympathetic case, but their interest in pursuing the matter might start to diminish once they've graduated. And they say, oh, like, what's this to me anymore? I want to move on. So it's difficult to attain that kind of motivated plaintiff for long-term litigation. What you probably are looking for is something that's a little bit more short-term. And this is a remedy that I've spoken about for BBC in the summertime. And I think it's a little bit underrated. It is also a little bit of a long, slow slog, but I think it's very important, and that's the freedom of information request. It's freedom of information requests are good for two purposes. One, you can actually sometimes get some meaningful information that will allow you to take a public stand and advance the debate. And secondly, it's simply the fact that it's requested keeps institutions on their toes. It makes sure that the university is doing the right thing every time because they know that an information request as to how they've made decisions can come at any time, and it only costs $5, and they have to respond within a month. And within a few months, you actually work through the process, and you can start to get answers. So I would very much encourage you, even if you're not directly associated with campus, you read something in the newspaper or on the internet, pay your $5 and file the FOI request. It can't hurt.
Thank you. Same question goes to Michael Bergman.
My view on these things is there's a short game and there's a long game. The short game is what can we do today? The long game is where do we want to be in 5 years from now? In the short game, basically, we are going to have to indulge in what might be called, and it has been called, lawfare. If you sue them enough with enough lawsuits, they will be bankrupted. And that's important because it's money that fuels the ability of the student governments and the anti-Semites and the pro-Palestinians to do anything. And they do get money from somewhere, so we should be funding our own. We need to find mechanisms to reach out to the broader student population. Is that ads in the student newspaper, if they publish it? Is that posters? Is that regular, timely speaking engagements by whoever, even if the speakers are shouted down by hecklers, which is likely to be the case? We have to also remember that although our community is centered in the GTA and in the Montreal area, it's not just about Montreal and Toronto. There are other campuses and other places in this country. And that may require different approaches and different mechanisms. We need to also begin to work with administrations. It's not enough, in my view, to go to university administration and say, this is terrible, this is awful. We have donors who are going to withhold millions and millions of dollars and whatnot. We need to suggest concrete ways by which university administrations can balance the need for academic freedom, informed, reasonable free speech, and the protection of all students, and most of all Jewish students. And we need to emphasize to universities, since World War II ended, there has not been so much anti-Semitic agitation on university campuses in this country. And it's being agitated for more and more and more, and finds willing ears.
Jill has her hand up.
Yes, thanks, Elite. I just wanted to read out, there's a couple of comments that have come in. And so one of our participants had some insights, and perhaps Michael, you want to comment after? So I'll just read it out. It's he says, one key point in the Chicago principles needs to be reinforced by the Jewish community. Disruptive protest or other means of limiting the rights of others to engage in free expression, work, and open discourse, bear with me, it's not easy to read this out, is not acceptable and is in fact, I apologize. Bear with me, I'm really sorry about that. I'm having trouble getting it on one screen, but hold on. I'm going to just reread it. My apologies. One key point in the Chicago principles needs to be reinforced by the Jewish community. Disruptive protest or other means of limiting the rights of others to engage in work and open discourse is not acceptable, and is in fact a violation of the university's commitment to free expression. There's not really a question, it's a comment, but I don't know if Elite, I'll hand it to you.
Problem with that statement, which is valid, is that the broader society in Canada and the United States does not completely believe in that. The world is changing, and the use of extraordinary methods that may have been rejected only a few years ago are now seemingly tolerated. Just look at what's going on in the United States, and to a much lesser extent in this country. The idea of shouting down somebody is not as heinous as it may have been before. It's now more and more an accepted tactic. When we tried to stop hecklers, which what the polite way, what they used to call people who disrupt, we are now accused, and anybody who tries to start is accused of silencing the right to speak. All of the rules have been stood on their head, and our opponents are taking advantage of that. As lawyers, we have a supreme duty to advocate actively and openly for the reinstatement of the proper rules of conduct and speaking, and oratory and logical presentation. Without that, if we don't do that as lawyers, then everybody else is going to say, well, it's a new world out there. So let's yell and scream.
I would like to add a comment on that point. The Section 2 of the University of Toronto Code of Student Conduct says that no person shall, by action, threat, or otherwise, a disturbance member knows obstructs any activity of the University of Toronto or any of its divisions, or a right of another member to carry on their legitimate activities or to speak or associate with others. For example, peaceful picketing or other activity outside a class or meeting that does not substantially interfere with the communication inside or impede access to the meeting is an acceptable expression of dissent. And silent or symbolic protest is not considered disruption under this code, but noise that obstructs the conduct of a meeting or forcible blocking of access to an activity constitutes disruption. So we do have in our university student codes of conduct, of which the University of Toronto Code is just an example, prohibitions on the disruption of meetings. And that includes meetings by authorized student societies. So if a Jewish student organization wants to have a presentation and let's say this put on a movie, Paul Newman's Exodus, for just as an example, and some people who don't like that movie burst into the room and start chanting to disrupt that proceeding, that is likely a violation of the Code of Student Conduct. So it's not that we don't have the right rules on the books of the universities. What we have is a lack of enforcement. And that's where national organizations, such as what Mr. Bergman is proposing, need to step up and step in and to make sure that the university, through perhaps freedom of information requests and other means, to make sure that the university's authorities do perform their jobs properly and do intervene to enforce these codes of conduct.
Thank you. Yes.
Sorry, Elise.
Yes, Jill.
I have one other comment.
Good.
So two things. First of all, if anybody has questions, please, if you haven't noticed in the chat, I asked if you could send them directly to me, and I will then read them out, and somebody just took me up on that. So I have a couple of things. So one of the comments is, universities can create advisory councils to foster Jewish life on campus. B'nai B'rith emphasized this point at the 2021 Canadian Summit on Combating Anti-Semitism, and there's a reference to an example in Illinois. I don't know if either of you have seen that done or have any comments on that.
Brian?
I personally haven't seen that, so I wouldn't be able to comment.
Okay.
Brian would like to comment. Brian Herman?
Alexa, can you unmute him?
Thanks very much. So I'm drawing in a couple of the comments that I've put in there on some work that B'nai B'rith Canada did at one point in time on a possible handbook to help implement the IRA definition of anti-Semitism in various parts of Canadian life, government, business, academia. And there was a chapter that we had on the role of universities. So my first point about the Chicago principles is that many people underscore the freedom of expression component that's embraced in the Chicago principles as justification for universities not acting. And in fact, there are balancing principles in that document that suggest, as I mentioned in the first comment, that there are limits to freedom of expression on campus. And I would agree that with Mr. Bergman, that one of the problems we have is not universities not enforcing their codes of conduct. The second point, though, is one that I think is always very important if we're talking about protecting Jewish students on campus, is that at the summit in 2021, B'nai B'rith Canada emphasized this point that we need to look more not just at combating anti-Semitism, but fostering Jewish life. And the example that I used, which is in that draft chapter that the organization prepared once upon a time, it didn't go anywhere for a variety of reasons, was to create these advisory councils on campus to talk about what can be done to foster Jewish life as one way of protecting our students. So there's a link there in the chat, and if the hosts want to send it around, it might be useful.
I fully agree with what you said, Brian. I think there has to be a very strong positive atmosphere of protecting and fostering Jewish life on every campus. That includes having the right real estate in the right places on campus. And that might take money, but I think every major campus needs to have a Jewish organization that's prominent, that has a high budget for advertising itself, that has significant and fun and inspirational events, that is linked to the local Jewish community, that's attractive to students, whether they are religious or not, whatever their denomination or degree of observance. And the other thing that maybe that organization has an Israel advocacy component, or a human rights, or a component, or an anti-Semitism watch component, but that can't be the only thing it does. It has to also just be a great place for Jewish students and their friends to hang out, and to portray an open, positive appearance of the Jewish community, and to get students to want to come there, whether it's for beer and pizza, or movie nights, or trips and excursions. This is the sort of thing that we need to have to make Jewish students feel popular and wanted on campus.
So if I may add this, I agree with all of this, but that's not by itself going to deal with the emergency that exists today. The world and where we live is growing more and more anti-Semitic. The taboo against anti-Semitism has been removed. We are under threat. College campuses are part of the place where harm is being done. As I said earlier, that harm is being cultivated in future generations of graduate students as they leave university. We need to look at this, that there is a deliberate effort by a number of highly organized groups, ideologies, convictions, whatever you want to call it, that is helping to promote this idea that Israel is bad and the Jews are bad. Pizza for students is important. Bonhomie, collaboration, collegiality is important. That's been going on. This kind of mechanism, suggestion, been out there for decades and decades. It's not adequate. The old ways aren't working, if they ever did work. We need to be more assertive, more aggressive. A lot of that falls to the role of lawyers, who are supposed to be the beacons and the defenders of rights and liberties and human dignity. For our community at large, and this touches on what this forum is about, but goes well beyond it, in my view, we need to convene an Estates General of the Canadian Jewish community to discuss where we're at, where we're going, and what's to be done.
Thank
It
you.
doesn't mean that I would refuse.
You know, I fully agree with what
I
you
would
said.
not refuse. I would not refuse a slice of pizza, by the way. Thank you.
Well, speaking of that, what you said was actually very important about being aggressive. And just as a case in point, you'll see on all the campuses the Palestinian flags being displayed in the student union cafeterias and the student union offices all over campus. Well, I think that our side, for lack of a better term, should not be shy about displaying the Israeli flag. And when it's turned down, when we are not allowed to put up displays of our own, well, that's when we bring in the Michael Bergmans of the world, and we bring in CJA and B'nai B'rith and the whole legal team, and we sue their pants off. because that's where we're being given second-class status, and we should never accept second-class status, and we should never let them win.
Michael, you're frozen or
No, I'm done.
Okay, good. Okay. So I'd like to thank you both for participating in this event and all the valuable work you do. And I'd like to turn the floor to Mr. Michael Mostyn, CEO of Neighborhood Canada.
Great. Thank you very much, Elite. And I guess I'm in good company with so many Michaels as participants on the call this afternoon, but I'd like to thank both of the Michaels for all of their thoughtful responses to all these questions. Thank you, Elite, for hosting today. Thank you to Jill, and thank you to all of you who are in attendance, whether on the Zoom or whether on YouTube. It's really, really important, particularly at this time, and Michael Bergman was just mentioning this. We know it's statistically, but anyone who has any involvement with the Jewish community knows the rise of anti-Semitism is very, very disturbing. If you are a Jewish legal professional, we would encourage you to please take this opportunity to join the Matus Law Society if you're not already a member. If you all are already a member, we have a number of legal committees that we are growing out and that we are building up. And we would encourage you to use your legal skills to give back in the fight for human rights and the fight against anti-Semitism. There are a number of areas where we need your help. We can't do this by ourselves. We need support for the community. So please join us, and working together, we will push back and we will make a positive difference for everyone who is disturbed right now with the way the trend lines, the way that things are going. So I'd just like to say once again, thank you to everyone for attending today. And Elite or Jill, any final words?
I just like to wish everybody happy holidays and a happy new year. And thank you for attending.
I'll just add to that. I'm dropping a link in the chat. If you are not a member of Matus Law and you'd like to join, you can register at that link. And also the next event will be for Matus Law Society members. It will be on January 31st, and stay tuned. We'll be sharing information on that very soon. And thank you everyone for your participation today.